Suing your employer in a workers' comp claim and third-party claims. Take 3, 3, 2, 1.
Hello, I'm Farah Farah, and welcome to The Legal View. Our firm is Farah Farah, and today we're going to be talking about workers' compensation. We get a lot of phone calls from people who are injured on the job, and we represent them in a workers' compensation claim, but they want to know if they can sue their employer or anybody else who is responsible for their injury. Bruce, give us some information on that if you can.
Sure, Eddie. Florida statute bars an employee from suing their employer in tort if they have a workers' compensation insurance policy in place, unless the employer's actions or negligence were intentional, or alternatively, if it's a situation where the employer knew of a situation to which they didn't disclose that information to the employee, and it was virtually certain that that person would be injured. So those would be the only circumstances by which you would be able to sue your employer. And the courts take a pretty strict approach in the interpretation of the statute and being able to bring those claims. In other situations, if somebody is negligent who is not affiliated with your employer, you can bring a lawsuit against them in personal injury. However, if it's on a construction site, all contractors that are on that construction site would be immune from being sued in personal injury. However, if you were working in a convenience store and let's say a Coca-Cola truck goes running through the building, you would have a claim for workers' compensation against your employer, and you would also have a claim against the Coca-Cola company for their negligence in their driver driving through the store.
Well, who's required to have workers' compensation?
All employers who have more than 4 employees are required to have workers' compensation coverage unless the employer is in the construction industry, and in those circumstances, if they even have 1 employee, they're required to have workers' comp coverage.
Let's say they're required to have workers' compensation, they don't have the comp coverage, and one of their employees is injured. Does that affect their ability to be able to sue their employer to get their benefits?
If the employer does not have work comp coverage in effect, and they should have, then the injured party has the option to either pursue the claim under the workers' compensation statute or alternatively in personal injury. The benefit of the workers' compensation statute and laws is that the work comp system is a no-fault system. So you would be able to still be covered for your injuries even if the accident was due to the negligence of the employee himself. So that would be the only situation, if the employer didn't have coverage, that you would likely want to file it as workers' comp. Otherwise, if the employer was negligent, then you would be able to go ahead and pursue that through tort, which gives them the opportunity to collect pain and suffering damages and other damages which are barred in a workers' compensation case normally.
Well, thanks a lot, Bruce. And if you have any questions about your workers' comp claim, we'll be glad to talk to you about it. You can contact Farah Farah, and we'll see you next time.